What happened to free Roman brides was humiliating. What Roman masters did to enslaved women was far worse. Imagine an 18-year-old bride, her hair bound with a saffron fillet, a thin veil slipping over her face as torchlight tremble along the narrow street. Songs rise behind her, fescinae and wedding calls that both celebrate and shame, while her mother's hands tremble at the hem of the procession. The house smells of crushed herbs and boiled wine. The city's laughter fades as she is led inside. What she expects and what those around her promise is the beginning of a household, a name, a dowry, a continuity of line. Instead, she is ushered by matrons and by law into a small, sealed room where strangers will watch and record what her body has become. What Roman masters did to enslaved women on their wedding night was worse than death. That is the claim we will explore, first through a documented ritual performed on freeborn brides, and then, cautiously and clearly marked, through the darker mirror of what power allowed masters to do to enslaved women. The public wedding in Rome was loud, ornate, and dressed in symbolism. It began with procession and proclamation, the bride in saffron, the groom in his toga, the pronuba, the matron's attendant, binding the ritual knot, the legal formulae that made the union a transfer not merely of affection, but of authority. Songs were sung that both blessed and humiliated. To be married in Rome was to be publicly situated in a web of relations. The ceremony performed a legal fact. The word manus, literally hand, named a range of legal effects. Under some forms of marriage, a woman passed into the legal control of her husband, no longer solely a daughter of her father, but a member of his household, subject to his authority in ways that mattered for property, for legitimacy, for inheritance. But the public pageant was only the stage. After the torches left the threshold and the neighborhood noises died down, certain households practiced an intimate, secret rite, a verification of consummation and virginity that involved a draped wooden figure and witnesses whose testimony might later decide the fate of children, property, and honor. Ancient sources allude to a phallic effigy, mutunus tutunus, a wooden emblem sometimes concealed beneath linen. They also mention a pronuba who supervised, and physicians or midwives who could be called upon to inspect and record. Augustine of Hippo, in his Confessions and in his polemics against pagan practices, recounts these customs with moral outrage. Arnobius and Lactantius, Christian apologists, also describe such rites as evidence of pagan obscenity. The Roman antiquarian Varro and later legal commentators offer fragments that show the ritual's legal function. The rites were not merely superstition, but served as practical proof, performative evidence that could be summoned in disputes over paternity or dowry. Reconstruction is necessarily partial. The texts are fragmentary and often hostile. The most detailed descriptions come from critics who had reasons to dramatize. That partiality demands caution. Still, the surviving traces point to a pattern. The household valued proof that a marriage had been consummated and that a bride had been virgin. Proof might be enacted in a ceremony where the bride, supervised by matrons, engaged with a symbolic object. Witnesses observed, physicians could certify a change in physical condition, and official testimony could be entered into records. This was not merely a private humiliation. It was a bureaucratic act, evidence taken, witness statement recorded, legal consequences mapped out. To the Roman household, a woman's body could function as document and the ritual as a forensic instrument. Picture the scene more closely. The torches snuffed, a narrow apartment lit by a single lamp. The pronuba,
An older matron, chosen for her respectability, arranges linens. A wooden figure, its shape concealed by cloth, is placed carefully on a low bench. The bride is guided forward in obedience to the ritual script. Matronly hands assist, while the household slaves stand in the corners, silent and watchful, their presence both necessary and subordinating. A physician or midwife summoned for the purpose might attend, not as a healer, but as an expert witness. If a medical inspection was performed, it would have been clinical and recorded, an assertion of physical change, often phrased in Roman terms that are blunt but not pornographic, whose legal relevance was acute. Did the hymen show signs of rupture? Was there bleeding or another sign used as evidence? Ancient medical authors and legal commentators used different terms and placed different weight on such signs. The result is a historiography rich in debate and poor in certainties. Why such insistence on proof? The logic was legal and administrative. Roman families were intensely concerned with lineage. The forms of inheritance, the transmission of property, and the social status of children all depended on the clear establishment of legitimate filiation. A wife who could produce no evidence of consummation or virginity could cast doubt on the paternity of future children, unsettle claims to inheritance, and invite social disgrace. The household sought not only to sanctify marriage, but to render it legible to law. Where a marriage established through legal formula, a transfer of authority, or the right to manage a woman's property, the verification of consummation became the last intimate step in a bureaucratic process, a personal act turned into a piece of legal evidence. The Roman legal imagination was sophisticated. Under certain types of marriage, cum manu, a woman became legally incorporated into her husband's family. Her dowry might become a transfer of assets. Her person, in ways that mattered to officials and neighbors, could be adjudicated. Roman law placed extraordinary weight on witnesses and documentation.
In disputes over dowry returns, paternity claims, or the legitimacy of children, testimony about what happened on the wedding night could decide whether heirs were legitimate or whether property would revert. That is why the ritual's witnesses and any medical testimony mattered. They were not idle observers. They were the machinery of truth in a legal world that required visible signs to secure invisible relations. It is essential to stress the fragmentary and partisan character of our sources. Augustine, the most vivid of the critics, treats such rites as proof of pagan depravity. His descriptions, while invaluable, are polemical. Arnobius and Lactantius, writing to condemn the old religion, had incentives to amplify stranger details. Varro and other antiquarians record customs for antiquarian purposes, but their motives differ and their accounts are often terse. Medical treatises record observations about the body in clinical registers, but were written for practitioners, not social historians. The result? A mosaic of testimony, each tile shaped by a particular perspective. Historians must read these testimonies against one another, weighing bias and seeking convergences. Now we must pivot toward the claim at the heart of this narration, the terrible and in many respects more brutal reality for enslaved women. The ritual, as practiced for freeborn brides, however humiliating and invasive, occurred within a legal framework that, at least in theory, conferred a status and, for some women, protections and familial identity. Enslaved women occupied a different legal space. Roman law treated slaves as property. Their bodies, labor, and reproductive capacities were controlled by owners whose rights were broad and often absolute.
The question before us, therefore, is not whether the same scripted ritual was universally performed on enslaved women. Sources do not provide a single, uncontestable page that reads, "Enslaved women were given the mutunis ritual," but whether the logic behind that ritual and the power of masters over slave bodies combined to produce abuses at least as violent as the ritual's worst excesses. We must be explicit. Where direct testimony exists about enslaved women being forced through a formalized wedding night verification, similar to that of free brides, it is limited. The surviving legal texts and anecdotes more often address in general terms owners' rights, sexual access, and the use of slaves' bodies for household ends. Roman jurists discuss an owner's rights to the sexual use of his slaves, and the law gives masters broad authority to determine the service and reproduction of enslaved persons. Owners could sell slave women who bore children or keep them for breeding. In certain legal cases, the status of children born to slave mothers, whether free or enslaved, became contested evidence.
The Roman household's concern with filiation and property thus intersected with the world of slavery in ways that made enslaved women especially vulnerable. Where the free bride's body was examined as a document, the enslaved woman's body was already dispossessed. The owner's power to use, to punish, to sell, to impregnate, or to withhold was embedded in law. In practical terms, that could be worse than death. The confiscation of reproductive autonomy, the erasure of a woman's claims to marriage, and the subsequent sale or punishment of mother and child. Ancient legal texts illustrate the asymmetry. The Digest and other compilations of Roman law record in clinical phrases the rights of owners. An owner could exploit the labor, the body, and the offspring of a slave. In court records and letters, we find cases where owners used slaves' bodies as evidence, or where disputes over the paternity of children by slave women became legal minefields. These records are not plentiful and often lack the color of narrative, but they show clearly that the legal apparatus treated enslaved women differently. If a free bride's virginity or lack of it could invalidate dowry claims or affect inheritance, a slave woman's sexual life was predominantly a matter between owner and household. The law did not, in general, presume that marriage created the same protective legal bonds for a slave as for a free person. When masters exercised sexual rights over slave women, when they decided reproductive fates and exploited bodies, the harm was systemic, routinized, and sanctioned by property law. We can illustrate the structural logic with an analytic comparison while marking evidentiary boundaries. For a freeborn bride, like Livia Tersa, our reconstructive example, there were social and legal expectations. She might be under a father's watch until marriage. Her marriage could transfer certain rights to a husband. Rituals could be performed to verify consummation, precisely because those rituals served to secure legal claims. For an enslaved woman, the starting point was different. She was legally owned. Her sexual life could be shaped by the owner's needs, economic, social, and personal. Masters could sexually exploit slave women to produce offspring for labor or sale. Masters could deny the slave any legitimate marital status, despite arranging unions for social display. Masters could use her sexuality as a tool of control. Because the law positioned the slave's body as the owner's asset, the kinds of ritualized verification that rendered free brides legible to the law might be unnecessary in their formal ritual shape, yet the underlying violence, coercion, and reproductive dispossession were amplified. This is where the historical imagination must be careful but honest.
Some scholars offer, based on legal texts, epigraphic evidence, and the logic of household control, plausible reconstructions of how owners might insist on proving paternity or enforcing reproductive control without necessarily staging the same publicized ritual. An owner could, for instance, require a slave woman to cohabit with a particular man as part of a household arrangement, or to undergo medical examination to certify fertility for breeding purposes. Slaves could be paraded in court as evidence of a master's property or as witnesses in a dispute, always subordinated to the owner's narrative. The point is not to invent identical ceremonies where the evidence is absent. It is to understand that the Roman household's hunger for legible proof and the legal entitlement of owners to control slave bodies together produced conditions in which enslaved women experienced coercions as intimate, invasive, and dispossessing, sometimes in ways that rendered them beyond rescue within the legal system. A few textual fragments and anecdotal cases point to this intersection. Roman jurists sometimes discuss questions of filiation when a slave woman bears a child. Who owns the child and what happens if the child is later freed? In some legal scenarios, owners' declarations about a slave woman's sexual status had consequences for property. In a society where the presence or absence of consummation could influence the return of a dowry or the legitimacy of heirs, you can see why households would have an interest in making sexual facts visible. For slaves, that visibility often meant being further entangled in the owner's property calculus. Owners could, with fewer legal obstacles than a free husband, exploit a slave woman sexually. They could also force medical procedures or sell women whose reproductive output was deemed undesirable. Again, scholarship must resist the temptation to translate this entirely into the vocabulary of modern criminal law. Romans did not always frame these matters in terms we would recognize, but the lived consequences for enslaved women were brutal and legally sanctioned. It is also useful to consider the social theater of witnesses and testimony. In the free marriage, witnesses could be summoned to attest to what they had seen on the wedding night. Their testimony spoke to social reputation and legal consequence. For enslaved women, witnesses were often themselves slaves. Their testimony could be bought, coerced, or disregarded. A slave's words held different juridical weight. Owners could manipulate testimony by controlling witnesses or by recasting physical facts as private matters of management rather than public facts of legitimacy. The asymmetry of voice, whose testimony counted, made enslaved women's experiences both more clandestine and more vulnerable to manipulation. The Christian critics of Rome, Augustine, Arnobius, Lactantius, offer a complicated but revealing layer.
Writing from moral and polemical perspectives, they seize upon these rites as examples of pagan depravity. Augustine, in particular, describes certain wedding night practices with alarm and disgust. He directs moral condemnation at what he portrays as ritualized humiliation and sexualized temple rites. Arnobius and Lactantius use similar examples to make rhetorical points about pagan moral bankruptcy. Their condemnations are not neutral records, they are moral arguments. Yet their vividness also tells us that such practices were visible enough to be attacked, and that the cultural debate around them was intense. Over the course of late antiquity, these Christian denunciations contributed to the marginalization and eventual suppression of some rites. Churches and Christian authorities forced the removal or destruction of certain cultic icons. Legal changes and Christian moralism reshaped public tolerances. Statues could be broken, cults sidelined, rituals reinterpreted. The process was not instantaneous or uniform, but the Christian voice played a crucial role in the cultural erasure of these practices from elite public life. That erasure matters for historians. When practices disappear from polite accounts, the voices of victims are not simply absent, they are actively silenced by successive cultures. The historian relies on the fragmentary record, hostile witnesses, terse legal clauses, later liturgical condemnations. Each layer of suppression compounds the difficulty of reconstructing what happened to those whose speech was not recorded, especially enslaved women. Christian polemicists condemned what they saw, but their accounts cannot be read as disinterested reportage. They sensationalize where it might serve their argument. They care less about the enslaved and more about the perceived moral decay of pagan rites. Yet their presence in the record is invaluable because it provides testimony to the ritual's existence and to a cultural dialogue that ultimately led to its attenuation. Let us return to the image of the bedroom-turned-courtroom and then step beyond it to think carefully about agency, voice, and memory. In the ritualized verification of free brides, there remained imperfectly a social script that incorporated matrons, families, and legal consequences. In the household of slaveholders, the apparatus of control could convert the most intimate acts into forms of punishment, commodity, or reproductive management. An enslaved woman could be forced into sexual relations with little hope of legal recourse. A slave's children could be claimed, sold, or used as capital. Where a free bride's exposed body might become evidence in the service of lineage, an enslaved woman's body could be evidence in the service of property. In both cases, the logic is the same: bodies made legible to the law. But for the enslaved, that legibility rarely led to protection. Instead, it often led to deeper commodification.
At times, historians confront striking testimonies that hint at the cruelty of masters in wedding-like contexts. A master might compel an enslaved woman to witness or to participate in rituals that humiliated or branded her as property. Owners might separate mothers and children. They might punish resistance with sale or physical sanction. The thin archival traces, letters, court records, ownership inventories, reveal a world where sexual exploitation coexisted with meticulous legal thinking. That conjunction is the crux. Roman law could be precise about heirs and dowries, while also allowing, within the category of slavery, extreme control over personhood. The legal mind that produced rules for verifying a bride's consummation also produced rules that enabled the owner's untrammeled authority over the slave's body. When we move from description to moral reflection, we must avoid easy equations. The freeborn bride's ritual was not the same as an owner's coercive sexual use of a slave. Yet, power under Roman institutions could make the latter more devastating in practice. For a free woman, even when ritualized verification inflicted humiliation, there was still sometimes recourse: witnesses, kin networks, normative expectations that allowed for reputation to be defended. For a slave, the law offered fewer protections. Masters decided, often unilaterally, what was permissible. The absence of legal standing for slaves meant that abuses could be structured, repetitive, and enduring. That systematic nature, supported by law and property, makes the claim in the title plausible in the moral sense. The cruelty enabled by owners' legal rights could, in many cases, be more destructive of personhood than a single ritualized humiliation. We must also confront the erasure of these stories in subsequent memory. As Christian authorities suppressed certain rites and as the empire transformed, accounts that once circulated were edited or purged. The very mechanisms that concealed the ritual's memory, destruction of icons, suppression of cults, reconfiguration of marriage law, also obscured the experiences of enslaved women. Later writers, often members of a literate elite, either forgot, ignored, or reframed what had once been common knowledge in domestic circles. The victim's experiences drifted into the fog of undocumented life.
When sources do preserve fragments, laws that discuss slave status, a jurist's note about paternity, a Christian polemicist's invective, they come pinned with biases and lacunae. Scholars must therefore read for absence as much as for presence. The silence around certain practices is itself a historical clue. What, then, are we to do with this painful confluence of legal sophistication and systemic dehumanization? First, historians must keep an unflinching gaze. To acknowledge the legality of owners' power is not to moralize with modern categories thoughtlessly. It is to record the structures that enabled brutality.
Second, we must distinguish between documented rituals and reasonable inference. When sources confirm the ritualized verification for free women, we can narrate it with confidence. When we reason about enslaved women, we must be explicit. The inferences we draw are built from law, from household practice, and from the logic of property. They are historically informed hypotheses about the lived consequences of ownership. Where documentation is absent or ambiguous, the proper rhetoric is hedged. It is plausible, the legal framework suggests, evidence implies, rather than declarative sentences that assert specifics as fact. Third, the narrative must center survivors' dignity even when voices are missing. That means describing these acts with sober language, verification, inspection, coercion, humiliation, rather than lurid adjectives. It also means recognizing the moral injury done by systems that convert persons into assets. The conceptual frame here is crucial. Roman law's precision regarding dowries and filiation coexisted with a set of practices that normalized the abrogation of autonomy for a large portion of the population. For enslaved women, the denial of autonomy could and did produce consequences that echoed across generations: loss of family bonds, commodification of children, and the erasure of narrative voice. Finally, there is an ethical responsibility in remembering. The rituals and abuses of the past were normalized by institutions that presented them as customary or necessary. Remembering means refusing that normalization. It means tracing lines of continuity where they exist, how domestic practices reproduced inequality, how legal categories framed human beings as assets, how power exploited the intimate for economic and social ends. It also means recognizing ruptures, the role of Christian condemnation in altering public sensibilities, the ways legal reforms and changing social mores eventually reduced the visibility or acceptability of certain rights. But remembrance must not collapse into simplification. The arc from ancient custom to Christian suppression was uneven, contested, and partial. Before we close, a short practical note for those who have been following. If the hidden horrors of the past fascinate you, subscribe and like so we can keep digging into stories that history almost forgot. We end where we began, with a young woman under a veil, whose life and body were made legible to law. The rituals that forced her body into evidence were not isolated curiosities. They reveal a civilization that prized legal clarity even at the cost of intimate dignity. The wooden effigy, the pronaba's hands, the physician's pen, these are the elements that turn marriage from a private bond into a public certificate. For free women, the ritual could inflict humiliation. For enslaved women, the law's entitlement magnified humiliation into dispossession. Where an isolated ritual could shatter a reputation, systemic ownership could erase personhood. That is why, when we say the actions of Roman masters toward enslaved women on their wedding nights could be worse than death, we mean this: death ends a life, but legalized domination could obliterate social identity, reproductive agency, family, and future. It could consign both women and their children to the marketplace. Our sources are imperfect, but their pattern is clear enough to indict the structures that permitted such suffering.
Augustine and Arnobius rant. Jurists record. Physicians note. Slaves themselves, when they leave traces, speak indirectly through sales lists and anecdote. Together, the fragments sketch a social world in which law and violence were intertwined. Remembering that world matters because it helps us recognize how legal systems can legitimate cruelty and how the language of proof can be mobilized to subordinate bodies. If you found this examination illuminating or upsetting, tell us where you watched from and what surprised you most. Share this with someone who cares about the long shadows of history, and subscribe for more deep dives into the past we thought we knew.